All right, if you're gearing up for the Queensland bar exams, you know that expert evidence can be an absolute minefield. So today, we're going to tame that beast. We're breaking down the key Uniform Civil Procedure Rules, the UCPR, that you absolutely have to have locked down. Let's get into it.
So, you know the scene, right? You're in court, and you've got one expert saying a building is perfectly safe, and another one saying it's about to fall down. It's the classic battle of the experts, the dueling experts. So how does the court possibly cut through all that noise to find the truth? Well, Queensland's UCPR has a very specific, and I mean very powerful solution for this exact problem.
And that solution, the starting point for everything, the court's preferred position, is to stop that batter before it even starts. How? By appointing a single independent expert. This is really the cornerstone of the whole modern approach to expert evidence here in Queensland.
The goal is so beautifully simple. One issue, one expert. It's all about efficiency, right? It's about preventing the whole case from just turning into this long, expensive war of opinions. For your exam, you have to remember this. This is the default position. It's the ideal that the court is always aiming for. Okay, so the court has its expert. What's next? Well, the rules don't just leave it there. They lay out a very clear, very structured process for how that expert's report actually gets created and brought into the case. And that whole process is governed by Rule 429L. You're going to want to remember that one. It's a pretty simple four-step journey. First, the expert does their work and prepares their report. Second, they hand it over to the court registrar. Third, the registrar files it, but in a sealed envelope. That's to maintain its integrity. And finally, number 4, within 7 days, the registrar sends copies out to all the parties. It's a really clean chain of custody, all under Rule 429L.
Now, of course, the court doesn't just appoint an expert and then, walk away. Not at all. Rule 429M gives the court these incredibly broad powers to manage the whole process. They can order parties to hand over info, they can direct inspections, they can even rule on who's paying for all of this. The key thing to take away from Rule 429M is that the court stays in complete control of its expert.
Okay, this is it. This is the part you've been waiting for, and it is absolute gold for an exam question. What happens when your side thinks the court's single expert has just gotten it completely, totally wrong? Well, let's dive into the rules for challenging them, and it all happens in the critical Rule 429N. First things first, let's be crystal clear about the default rule. Rule 429N subsection 2, it says that unless the court orders otherwise, the court-appointed expert is the only expert who can give evidence on that issue. Period. That's it. That is the massive brick wall that any party wanted to call their own expert has to climb over. And this, of course, is the million-dollar question, isn't it? If you get a report back that you are convinced is flawed, are you just stuck with it? Well, no. The rules do provide a very, very narrow gateway for a party to argue for another expert to be heard. And those gateways, they are found right there in Rule 429N subsection 3. You, as counsel, have to convince the court of one of 3 things. 1, there's a different expert opinion out there that is material to the case. 2, there's another expert who knows something important that the first expert didn't. Or 3, there are other special circumstances. You have to know these 3 grounds from Rule 429N3 cold. Now here's a really subtle but vital distinction for your exams. The power to allow another expert under Rule 429N2 is a broad, unfettered judicial discretion, but the power under 429N3 is totally different. The court's discretion is only, and the cases use this word enlivened or sort of switched on, after a party has proven one of those 3 specific grounds. It is a much, much tougher test to meet.
So just how tough is it? Well, this quote from the key case of Connius Hotels tells you pretty much everything you need to know. The court says that simply finding another expert who happens to disagree, well, that's usually not going to be enough, especially in areas like property valuation where opinions can naturally vary a bit. You can't just go expert shopping for a better opinion.
And the case of DVS just hammers this point home. In that case, the judge basically said, look, the applicant agreed to a joint valuation, and then they just didn't like the number that came back. Well, too bad. That is not a special circumstance under Rule 429N3. The courts are incredibly reluctant to unwind this whole single expert process just because one side is unhappy with the result. So when you boil it all down, it comes to this. The court is only going to grant leave for another expert if the interests of justice absolutely demand it. It's a balancing act. On one hand, you have the need for efficient case management. On the other, you have the fundamental need for a fair trial.
The ultimate question is, will refusing to hear another expert deny a party a chance to present credible, significant evidence? That's the real test.
Okay, let's pivot for a second. What happens in that other scenario, where the court does allow multiple experts? The rules don't just, let them loose to battle it out in court. Instead, the court will often direct them to confer and produce a joint report. And for that, we look to Division 3 of the rules.
Rule 429A sets out these really strict rules of engagement for their conference. And there's a huge emphasis on independence. The experts have to use their own judgment, they have to try to reach agreement, and, critically, they cannot act on instructions from lawyers or clients to withhold agreement. Their ultimate duty is to the court, not the person paying them.
The whole process is also super structured to protect that independence. Under Rule 429B, all communication is basically on a CC all basis. If an expert needs some info, they have to write to all parties. If a party responds, they have to write to all experts. Everything is out in the open, which keeps it all transparent.
Now, this is another critical exam point. Rule 429C creates a kind of safe space for the experts to talk freely. Think of it as the Vegas rule for expert conferences. It says that anything said or done during that conference is inadmissible in court, unless every single party agrees to let it in. This lets the experts debate and even change their minds without worrying about it being used against them later on.
But, and this is the huge exception you have to remember, that protection does not apply to the final product of the conference, which is the joint report. That document, the one that shows what they agree on and what they still disagree on, is absolutely admissible in court. So the discussion is protected, but the outcome isn't. That's Rule 429C, subsection 2.
So, as we wrap this up, let's leave you with this question to chew on. The single expert rule, it's designed for efficiency, right? To find objective truth. But is there a risk that it can become a hurdle to justice if a party is stuck with an opinion they believe is fundamentally flawed? Knowing the rules we've just covered, from 429L all the way to 429N, is the key to making that argument. And that's your takeaway for the exam. Good luck!